if an employee is paid off the books, let's say in cash, for instance, there is no law against that in New Jersey or anywhere else. Where it gets a little tricky is whether or not the employee is paying taxes on that cash. Now, I would suspect that if a person wants to get paid in cash, they're doing it so they don't have to pay taxes, and I understand that. And in many of those situations, or the great majority of those situations, and there are some exceptions, they're usually lower wage people. However, it is a prevalent practice in the area of construction. A lot of times construction, not so much companies, but contractors, they need day workers. And I've had dozens of those cases where they're really not on the books because they're not permanent employees. They're what we call a casual employee under the workers' compensation statute. And they're paid, let's assume, $100 a day, and they're injured while they're doing that job. Well, they still have a workers' compensation case. There's no, you're not foreclosed from pursuing that. If they're legitimately injured, they do have a right to get the medical attention that they'll need. And it only becomes an issue possibly down the road if the injured employee doesn't declare that cash that they're earning, because it just happens if it's a contested case and the insurance company attorney asks that question while the person is under oath, and they say they don't pay taxes, it does raise an issue for them, and sometimes a judge won't want to hear that, and I'm not sure what the remedy is going to be, but there's no law against it, and for sure it is common in day labor types of jobs. It could be waitering, waitressing, for sure in the construction industry. But so long as somebody is what we call a casual employee, there's no law against that, and it's fine.